And we're off. Hello, Diane. How are you?
I'm good, Sean. How are you?
I'm doing well, and it's you and I have not physically seen each other in a while, and certainly not
Agreed.
over Zoom, but we communicate quite often via email because we're both in a world that has news breaking, it seems like every second of the day and whatnot.
I agree.
So,
I
but
agree.
it's really nice to see you, quote unquote.
Same here. Yes.
I really want to thank you for doing the video. And before we get started, I want to thank all you who have turned in to check out this video on Did You Know That? ? Which is my YouTube channel, passion project, if you want to call it, where I get to talk to interesting people about interesting things. And today is going to be a good one. So I'm hoping you hang around and whatnot. For those who are new here, please, if you like the video, hit the subscribe button with the bell so that you get the notifications. If you're a returning customer and already subscribed, thank you very much. And again, my name is Sean O'Rourke. I'm a cyber liability consultant, which means I basically prepare companies to be hacked. And this is my friend Diane. And Diane, why don't you tell the good folks who you are?
I am a lawyer and a good friend of Sean's. My specialties are cybersecurity and corporate law, focusing specifically on technology. And we do a lot of compliance work, security, technology work, and obviously work closely with Sean.
Well, luckily, not on any of our clients so far, but on educating people. So
yes,
someday one of my clients is going to really screw up badly. I know it, but
right.
Until that point. Okay, so Diane and I live in a world of digital communications, data, and whatnot. And regulators around the world are trying to catch up with technology, which is always the case. Technology is always, in some instances, a generation ahead of where regulators and the law catch. So Diane, take as long as you want, but give us the general lay of the land, both domestically in the US and possibly state by state, if you want to touch on some states, and internationally when it comes to cyber regulation.
Well, as you said, it changes all the time, but as most of the audience probably has heard, the EU's General Data Protection Regulation became effective May of 18, and that really is sort of the gold standard for international cyber and information privacy regulation. Brazil and Turkey have enacted similar laws modeled on the GDPR. Unfortunately, I don't think the U.S. is going to do that. There was a lot of buzz, Sean, I guess as you will recall, I would say probably last spring. It kind of peaked at the IAPP summit, the global summit in Washington, D.C., that there seemed to be sort of a groundswell among legislators to try and standardize at the federal level some sort of privacy regulation that would mimic GDPR. But they just couldn't get it done. There's too many differing views. And so it remains a state-by-state matter in the U.S., and I think it's going to probably remain that way for at least the near term. We do have HIPAA and GLBA for the healthcare and the financial services industries, respectively. So those sectors are fairly well regulated, but for everybody else, it's still a state-by-state affair in the U.S. Now, that's not to say that the U.S. hasn't done some things, and I'm sure everybody's aware of the CCPA out in California.
Sure.
Yep. And that took effect January 1st of 2020, although the enforcement of that, Sean, has been a little bit spotty. The AG does not seem to be too inclined to enforce non-compliance, or at least so far that seems to be the case. And COVID obviously has put sort of a damper on a lot of regulatory action. Nevada also enacted a law in October of 19, which gave consumers certain rights to their own personal information. Other than that, pretty much Florida, Massachusetts, Colorado, Texas require entities that own or license personal information to implement and maintain security procedures that are quote unquote appropriate to the nature of the information
Right.
and the size of the entity. So in those few states, there's more of a proactive push. Ohio sort of set out some parameters of what they would consider to be safe harbors for, you know, appropriate and regular and reasonable safeguards for protecting data information. So Ohio's law is probably a good one to look at in terms of crafting sort of a safe harbor. New York.
Because Ohio, just to interrupt you there for real quick, because Ohio's safe harbor is based on technology standards like
Exactly.
NIST, and there's 3 others. I know there's 4. I just know NIST is one of them.
NIST is the major one.
Yeah, NIST is the most well known.
Right.
So as long as a company can document, I don't think the word prove is really appropriate in that, but can document that they followed these standards. Ohio offers a bit of a mitigation of your liability, not your responsibility, but your liability, if anything happens within the state borders.
Exactly. Because the you know, the precautions that you take, or the you know, safety measures that you enact, just have to be reasonable and appropriate to your size, to your scope, to the kind of information that you have. So, you know, I mean, we've had a lot of clients that have decided not to make the capital investment in you know, going forward with a higher grade of firewall, but they've enacted policies or procedures, you know, double logins, you know, dual tracking that minimize it, and they just, you know, for whatever reason decided, you know, under the business judgment rule, they weren't going to make the capital investment at
Sure.
that time, but they took other measures because they knew they still had to, you know, be reasonable and appropriate. So
well, and let's be honest, to a lawyer, reasonable and appropriate is depending on what side of the aisle you're sitting on, correct?
Correct, yes,
Yeah,
exactly.
so your idea of reasonable and appropriate for your client may not meld well. Let's say you're on the defense side with a plaintiff's attorney's interpretation. And then so that's where the arguments really ensue. So you were about to move on to New York, because New York's an interesting state when it does come to cyber digital data and the such.
Yeah, New York's usually, you know, they're sort of with California, they're usually a leader. And I think that comes out of the historically financial bedrock, you know, of the state. And, you know, a lot of the, you know, economic firepower of the state is based in the financial services industry. So they're much more, I think, forward looking on that than most of the other states. And they focus on how the entities secure the personal information that they have. And they have a number of specific cybersecurity measurements and processes that you have to follow in order to be, you know, doing business in that state or licensed in that state.
And where the real uniqueness comes in, to your point, is that what you just referenced is probably the DFS, the Department of Financial Services, Part 500. But then they also enacted SHIELD. I guess they were trying to you know, ride the coattails of the big Marvel movies. But they enacted SHIELD, and SHIELD does focus on the general business consumer side of data.
Right. And SHIELD also, Sean, really is much more analogous to the voluntary NIST protocols too. They pretty much follow that. So that's the framework for security practices it's most analogous to would be NIST.
So when you're going to your clients, and this was an interesting point, and we didn't talk about this ahead of time, because if everybody has watched any of these videos, you know we don't necessarily go into these blindly. We do talk ahead of time to organize our thoughts. But one of the areas that we didn't touch on is how the SHIELD law and the CCPA out in California are akin to GDPR in that they focus on the data of the state residents as opposed to where you actually do business. So you may not do business in those states, but if you hold the data on those residents, then you're subject to it, correct?
Yeah,
If I read those
exactly
right.
right. That is exactly right. That is exactly right. And, you know, the Shield law in New York lays out the numerous security practices that you have to take in order to protect personal information. But now GDPR and CCPA only require covered entities to reasonably secure, and they don't give any other guidance. You know, GDPR is reasonable and appropriate, and I think that's what the CCPA says as well too. So they leave it then to the individual entity, and that's why states like Ohio and New York that lay out certain things. And you're right, DFS is only for financial services groups, which aren't necessarily regulated by the SEC or GLBA or
Right.
whatever. But it gives you a framework that you can look to, because everybody else, you know, retail, manufacturing, services, all of those are the wild, wild west, right? I mean, there's no regulation on any of those.
So this leads into one of the questions I did write down. If you're going into a business, let's say you're going into a client, they haven't had an incident, they're just looking to be proactive, and they're bringing you in. What regulations are you telling these businesses to look out for, or to sort of model their cyber compliance program on? Does it depend on the industry? Does it depend on the size?
Yeah, industry, size, location, because a lot of the states, you know, the third circuit is pretty active. The Second Circuit is pretty active. The Ninth Circuit is pretty active. But if you're outside of those, you know, federal districts
Yeah.
for law, you know, there haven't been that innovative, and they haven't been that how do I want to say this, prescriptive about what they want to
Okay.
see. So I would say probably, in my experience, Sean, CCPA, Shield Act, and I have to tell you, I really like GDPR because it's really
Really?
very
Okay.
rational, and it's very reasonable, and it's very it gets the job done if what you want to do is protect personal information. It gives people control over their information to a certain extent, but it requires the company to take measures ahead of, so that you don't have a breach, you know?
Right.
So I like that. We've tried to incorporate that into some of the compliance programs that we're promoting. So
That's interesting, because I'll be honest, I found GDPR sort of onerous, but again, I'm not a lawyer, I'm a consultant. So
sure.
what I'm doing is akin to what you're doing, but different
Right.
from that perspective. So I modeled mine actually off of New York's DFS, the Part
Yeah.
500,
Yeah.
simply because one, it was much shorter to read.
True.
And two, I thought they actually talked to technology and IT people when they
That is
wrote
true.
these.
That
And
is true.
so it made it, given my background in
Yep.
IT and whatnot, it made it
Yep.
easier for me to explain to an IT department and a business boardroom
Right.
what the requirements were and why they needed to do it.
Yep, yep. I have to say, I do agree with you on that, because they really spell it out, and you can see exactly. You can write your policies off of it. You can write your procedures
Oh,
off
yeah.
of it. It makes it very easy to comply.
Yes.
Yeah,
Well,
I agree with you.
and I was writing some of the compliance early until I talked to you. You were the one who told me, don't do that anymore. You need a lawyer to write these, because it has to be in legal speak, because
Right,
that's who's going to come knocking on the door after a cyber incident.
right, exactly. Yeah, exactly, exactly. You know, it's interesting. We've got a number of clients who are licensed through DFS. And so we, you know, obviously talking to some of the regulators there, and they have put a large number of resources into the technology side, into Section 500, in terms of monitoring, in terms of compliance, and in terms of, I don't want to necessarily use the word consulting, but sort of helping out the smaller groups out there who
Right.
service a segment of the population that maybe otherwise wouldn't be able to buy insurance, or wouldn't be able to, you know, finance something if it weren't for, you know, this group of financing companies that are out there, but they come under the rubric of DFS and therefore still need to be compliant, but don't have quite the budget of a Bank of
Sure.
America or another, and so the regulators have sort of taken on, I don't want to say a consulting role, but a little bit more of a hands-on role.
Well, I was quite surprised when DFS was making its rounds, and I started to look into it. All the industries that are covered by the DFS, and to your point, the various sizes. I mean, they go from solopreneurs, one-person companies, all the way up to J.P. Morgan and Bank of America and such. So,
I agree.
When I started talking to the really small folks, they were freaking out, and when I explained to them all that they had to do, well, then they realized, okay, I don't have to spend a ton of money.
Exactly.
I just have to be smart.
Exactly. Right. I have to think about it, and I have to have shown them that I thought about it and that I've taken steps to mitigate, to protect, it didn't have to be that. I didn't have to break the bank to do it. Yeah.
Right. And they don't have to hire either you or me. They can actually do that with a fairly decent IT company who understands what the requirements are. Now, I want to jump off because there is a topic that I want to talk about. It's a little political, but you and I don't necessarily care about that. We care about the laws that they're talking about, in that there is nothing federal. There's no federal umbrella law like GDPR.
No.
And even during COVID, Congress was very proud to traipse out via Zoom or whatever they did, all the tech folks, Google, Amazon, Facebook, and what have you, which was for antitrust. But really, that's where they look at. Do we not have a GDPR type deal because of politics? Because Congress doesn't understand how to make it work? Or is there really no political will to do it?
You always
it's a loaded question. I know.
Yeah, you always ask these really good questions because, like everything in Washington, it's multifaceted.
Right.
Nancy Pelosi is in California, and they've got CCPA, and she's a big proponent of that, and I think is very proud of that legislation. I know she would love to see something passed, while Mitch McConnell, on the other hand, I think does not see that there's a need for it. He feels that state by state is better because they're closer to the companies in their own, borders, and they're closer to the ground. They understand things more. So, I don't know, like everything, it seems to be a stalemate. And I do think it's more political. Because
do you agree with that assessment? Do you think the states know better?
No. Yeah. No, I don't. I think it should be a federal. I think it should be a federal. And I think, like everything else, I mean, there's wildly varying capabilities, capacities, knowledge pools, usage patterns that, if you had the bigger guys with the more experience on a, some kind of a, put together a consortium or something to share information, and it would be much better. But I don't know that we'll ever get there. That's where we were kind of at in the spring of 19, after GDPR had rolled out, and it was clear that it hadn't, toppled the world. Yeah, it hadn't toppled the world. Everybody was able to comply, and it really wasn't that bad. And there was a groundswell to do something, and then it just fell apart. And I think it was lack of political will.
Yeah. I mean, I'll be honest with you. This isn't a political statement. I hate it by state, because then everything is interstate commerce now. Nothing is just within your state.
Right.
If you're online. And so going state by state, you have to decide, well, what's Alabama's breach notification law and requirements versus Alaska's?
Exactly.
And all of a sudden now you're fumbling through. I do like New York Shield law requiring you to know where your customers are located.
Right.
That I like. But
I agree.
I mean, not having something standardized, I think, one, keeps you in business, keeps you busy, because now you have to go across 50 states.
True, but like you and I have talked. Yeah, but like you and I've talked, though, you know, it's the firemen, right? So you get called in for the fire and you do
Right.
all of these, you know, regulatory compliance things, but that's a once in a lifetime thing. And then they don't need it again. And you've spent all this time and money. And if you'd spent that on the front end, you know, trying to prevent what happened, it would probably be a better result, you know?
Yeah. And it really, I mean, if every state took CCPA or DFS Part 500, again, just my opinion, and just copied it and put their
Yep.
state logo on it,
Yep.
then I'd be okay. Because then there'd be some sort of standardization. But at the moment, I mean, it's just, to your
The
point,
Wild
Wild
West.
West, and
Yeah.
it's
Yeah.
annoying.
No, great.
Okay, so unfortunately, we agree on a lot of stuff. So there's not a lot of back and forth that we go on. But we are going to get into now to the second half of the conversation on a really big topic the last couple of years. Well, let's be honest, since 2016, and that's China. And
Oh,
that's
yeah.
how the US looks at China's technology company. Now, I'll be perfectly upfront with everybody watching. I think China is where it is because it stole most of its intellectual property to get a kickstart on stuff.
I agree.
But
I agree.
we're talking about not what they did, but what they're doing. And so as we record this toward the back end of 2020, there's a lot of companies in the federal government's crosshairs.
Right.
And you're international, you do domestic and international work. So give me your impressions on what the Trump administration is doing when it comes to WeChat, TikTok, Huawei, sorry. I was going to say Yahweh, but Huawei and
Yeah, it's pronounced a lot of other ways.
yeah, exactly. When it comes to that, and then we'll expand on this conversation as we go.
Well, my obviously just my opinion is I think that TikTok and WeChat appears to be driven probably more by election year politics than actual concerns about the cybersecurity of the platforms. I think he was elected, you know, well, in part anyway, on the strength of his pledge to curb Chinese influence. So as election year comes closer and closer, he needs to make noise about doing, you know, something about that. And I mean, I think he has done something with Huawei, or however you want to pronounce
Huawei,
it.
yeah, however.
I think he's done a pretty good job of that. I mean, that's like, you know, they decided to kill it, and they, you know, piece by piece, chopping the arms off and then the legs off, and then, you know, with this last decision by India a couple of days ago.
Yeah, that was huge.
I mean, that's huge. And India's right in their backyard. And they have money. So, you know, Beijing came out immediately and said, well, you know, don't worry, there's going to be plenty of money there. It's not about having the money. It's about having the customers.
Right.
And if you don't have customers, you can have all the money in the world, but you're not going to, you know, go anywhere. And I think
you're not going to get much more of it.
No, right. And I mean, the money alone, you have to have a use for, you know, I mean, you just have to have a base. And if all of, you know, all the major players are going to move away from that because the U.S. has said you can't do business with them. We're not, semiconductors are now dead to you.
Yeah.
They've got a storehouse, but, you know, they say they've got, you know, 6 months of that. And I think the estimates are more like 2 months, and then they're out. So, I think the Trump administration has done a very good job on that. And I think that Beijing knows that the policies are already in place. And regardless of what Biden may think personally, he's going to be locked into some of these positions because the U.S. has taken such commercial action that I don't know that Biden wants to undo it, but even if he did, it would be difficult to do. So I think they are starting to feel the pinch of we're just not going to take it anymore, and evidenced by the closure of the facility in Houston. I mean, they were clearly taking energy and agricultural data because they have the largest population in the world, and they need energy and they need food. So if they can, you know, cut better deals on trading commodities or trading for energy in the future, they're going to use that data. And, you know, the owner of the data may not see the value in it, But when you're aggregating data on the sort of the basis that they do, long-term effects of that data, you are going to feel it. And it's not right that they have access to that without paying for it or otherwise getting it in a legitimate way.
And to sort of further pile on China at this point, basically what you're seeing in the U.S. now is somewhat of a mirror reflection of what China does to other international companies, non-Chinese companies. I mean, non-Chinese companies cannot own businesses in China. They can have everything manufactured, but they can have no ownership there. China now, especially with the new Hong Kong national security regulations, now has the right to request data, though kudos to the US companies for the moment in rejecting those requests from China. So, I mean, this is everybody who wants to get up in arms about it. This is just what's happening on the other side of the Pacific. We've just brought it home and made it open, as opposed to what China does and just does it behind closed doors.
I agree. And I think, Sean, if you go back and you look at the roots of this, I think that the United States critically miscalculated China. Go back to say 1998, 99, 2000, when they started opening it up. They let China become, not we let, but we voted for and encouraged, World Bank entry, IMF entry. We wanted them to be, exactly. And we wanted them to be a partner. And there was this great globalization role, and, we buy, they buy, we ship, they ship, it was this great trading partner relationship. And I think that was generally pretty good. But the miscalculation was that they would play ball with the rules of the United States, the Western world, in terms of contract law, in terms of intellectual property rights, in terms of fair play from a philanthropic standpoint, defense standpoint, and that just didn't happen.
Nope.
And I think that right when we were making that calculation based on an industrial world model. And right at that time, the economy is changing from an industrial world into a technology world. And they win because they've got 1.4 billion people and we have 300 million. They have a lot more data, and the technology for them, that's really the only thing they know. They kind of missed out on the industrial, and we were making calculations on an old world model.
And we turned a blind eye to the IP, the intellectual property theft.
Totally.
For convenience reasons, because we being U.S. companies saw the cheap manufacturing labor and facilities and their disregard for environmental provisions as a way to, I'm not picking on Apple, I'm just using it as an example. Apple's a $1 trillion company because their margin on an iPhone is so extraordinary on just the device itself because it's made so cheaply in China. If you were to bring it over here to make the same margin, the phone would probably be $3,000 as opposed to $1,200.
Right. I agree. Yeah, we did that for convenience sake and for profit's sake, and we just miscalculated. We expected them to act like Japan. We let Japan in after the 80s, and Japan played ball. And they've been a great partner, and they got contract rights. They adopted a lot of our, legal system procedures, processes, and for lack of a better word, mores. And China has disregarded all of that. And by the time we really woke up to the fact that they really weren't going to play ball, to your point, we had 15 years of intellectual property has been out the door. Yeah, agree.
So if a client of yours is operating in China, let's not say manufacturing, let's say their technology, they're working with a partner over in China for a technology effort, and China does come to make a data request. How do you think you would handle that? Or would it be a boardroom decision more than a legal decision, do you think?
Oh, for my clients, it's always a boardroom decision
Okay.
because there's always the politics of it and the strategic, and they'll usually call in a consulting firm, you know, a BCG or a McKinsey for a limited view of what's the downside of doing this, and you know, and then they'll make their decision on that. But no, it's always been, in the few times that I've had that, which have been probably 3 in the last 8 months, it's been a boardroom decision, Sean, every single time.
That's not a few times. 3 in 8 months. That's,
Well,
you know,
because more and more is moving over. I mean, you know, more and
yeah.
more is moving over there. They can do it cheaper, although they seem to be moving away from that too. They don't want to do it now as cheaply as they were able to do it 10 years ago, 5 years ago.
Well,
So,
because they see Apple as a $1 trillion company, and they're like, hey, you're doing that off the back of our labor.
yeah, yeah,
Uh,
that's true.
yeah.
Yeah,
Okay. So from a data perspective, let's say your company, so it's interesting, and this is one we didn't talk about. The NBA has announced a deal with TikTok,
yeah.
which means NBA players, and the NBA is huge in China. That's
Oh,
why
yeah,
when the Houston Rockets general manager in the beginning of 2000, or beginning of the season in 2019, tweeted support for the Hong Kong protesters, I mean, China went that crazy
right,
and took them off television out there, and the NBA sort of was like a poor puppy with its tail between its legs.
right.
But to that end, a lot of that data does wind up in China. I don't care where the servers are. I don't
I
care
agree.
where it initially hits. It does end up in China. Does that present any potential conflicts with U.S. regulations for your clients? Now, you have medium-sized to larger clients, but
Yeah,
let's say they were about to do a deal with TikTok or WeChat or something, and you kind of knew data was going to wind up in China. How do you advise them? What are you telling them? And I'm not asking for specifics. I'm just
yeah.
asking
No,
off
no,
the top
no.
of your head.
That's a really good question. Um, if you know that data is gonna end up in China, and I agree with you, if you're doing business with a Chinese entity in some form or fashion, whether it's a joint venture, whether it's an acquisition, partnership, you know, whatever, merger, um, usually what we'll do is try to, at the board level, try to decide the downside, and then if there is a significant downside, but they still want to do the deal, then we call in um, the technology companies to help craft some type of firewall around that so that we can monitor what the usage of that data is. And you try then to draft agreements. It'll go into whatever the operative document is
Sure.
on data usage and notifications if there's been a problem, because you know stuff happens even if it's not intentional, you know. But you try to safeguard it as much as possible, but you know once it's gone, you know, and you gotta make sure you got insurance, right? I mean, you know,
Oh, yeah.
cybersecurity insurance is huge, and some of the insurers, there's a higher risk premium if it's going there.
That is true. Yeah. I mean,
You're going to pay more for it.
yeah, usually on the larger, mid-sized to larger companies, yes, there'll be a more,
Hmm.
I don't want to say invasive, but it is an invasive application process, and they're going to want to know where that data
Yep.
is going to reside.
Hmm.
So I know we're butting up on almost 40 plus minutes, and we could keep going. I mean, we joke that we could talk for hours on
Hours,
this,
yeah,
which we could.
days.
And
Yeah.
I promise people, if you enjoyed this conversation, there will be a part two, because there's a whole host of topics that we haven't gotten to. So I want to close it out with this. Hopefully the people who are watching this at any given point in time are with different size businesses. If most of them aren't going to be able to come to you because they don't have the resources to sort of structure themselves this way. But if you were going to give them some free, friendly legal advice, which is just your opinion and your advice, not of your firm and whatnot, what are you going to tell business owners right now when it comes to the proliferation, easy for me to say, of digital data and how they should be handling it? and what they should be doing with their companies to protect themselves?
I would say, and this circles back to what we were talking about earlier in the conversation, I would look at DFS, their rules, and I would look at Ohio. And if you could structure a program that basically complies or comports with those two states, I think you're gold.
That's good. Succinct, to the point, and dead on. Excellent. Well, this was fun.
Oh, it was great fun. Always a good time to see you.
Absolutely. I mean, if you guys can't tell, Diane and I have mutual admiration society, and we sit on,
yes.
We actually met because we sit on so many panels together to discuss this topic. But Diane, this was great. Thank you very much.
Absolutely,
You're
my pleasure.
Diane's LinkedIn profile in the video details. If you want to reach out, drop her a message, be courteous. She is one of my favorite people, and she will get back to me. Feel free to do so. Again, for everybody who joined in and watched this, thank you very much. Hit the subscribe button if you want to know when future videos are going to come out, and there will be more. But until next time, this is Did You Know That? I'm Sean O'Rourke. That is Diane Reynolds, and we thank you for joining us. See you, Diane.
Thank you. Bye.